Perfect. Okay. So this is what we're here to talk about today. 2025 housing legislation. And this is an update for planners. That's me. You don't need to know much more than that. I'm boring. Let's move on. So this is kind of our agenda. We're going to talk first about bills, then about cases, then we're going to get into some practical considerations. And then I hope we have a lively and helpful Q&A at the end. So first we're going to talk about bills, and we're going to start out with this one, which seems to be on everybody's mind, SB 79. Technically, it's called the Abundant and Affordable Homes Near Transit Act. I wish they would ask me before they'd name the bills. We'd make the names a lot shorter. But the focus, as you probably already know, is this is about TOD. This is about transit-oriented design and development near, and it includes zoning reform and it impacts local control. So where does this come from? It's not out of the blue. It has been years in the making. There have been various attempts and iterations at doing this. It, excuse me, going back to as early as 2008, when SB 375 at the time first codified transit-oriented development. They've been tinkering with it since. Early TOD was mostly just a planning tool, long-term planning tool about density near transit stops. Now, some of the prior efforts that we've already seen are, some bills from 2018, 2019 that were floated, but they failed. And then we really saw some traction in SB 9, what we still commonly call SB 9 from 2021. That's our by right second primary dwelling unit and urban lot split. And then we also had a year later, AB 2097, and they both kind of tangentially impact TOD. But then SB 79 is really, a lot of us think about it as the successor to SB 50, which was floated and died because it was just so ambitious. But SB 79 was passed, obviously, and it adds binding upzoning and state oversight. So let's get into it. What does SB 79 do? Well, it makes housing an allowable use near major transit stops, regardless of what your zoning says. And it expands the rights for TOD development. There are two key mechanisms here. There's an automatic upzoning that kind of tiered like a wedding cake with the transit stop at the middle. The cake stops at a half mile. So we'll talk about the tiers within that half-mile radius in a minute. And then the other thing that might be more relevant to some of you and less to others is that it transfers land use authority for those little bubbles around the transit stops to transit agencies on transit-owned land. They basically get to write their own zoning rules. Now, when does it apply? You should all have this date. Get out your red Sharpie, put this on your calendar, circle it. On July 1st, 2026 is when it takes effect. There is a delay for unincorporated county areas that might apply for some of SACOG's members. Where does it apply? Well, this is really important because it doesn't apply everywhere in the state. It's limited to urban transit counties. You can see that it's defined as counties having 15, I think it's 15 or more, but maybe it's just more than 15 passenger rail stations. As a practical matter, it boils down to just these few counties, and I've got Sacramento highlighted in red for obvious reasons. You should know, though, that there is a carve-out. It's kind of, the nickname is the Beverly Hills carve-out for cities that are smaller than 35,000, that have a population that's smaller than 35,000. They do have reduced obligations, or yeah, I'll call it reduced obligations, and we'll see some of that as we go through. So the law talks about TOD zones, and there are different ones. I think about it in terms of three, actually. There's immediately adjacent, there's a quarter mile, and then there's a half mile around the major transit stops. Now, what are we talking about with a major transit stop? It's heavy rail, high frequency commuter rail, light rail, or BRT. So in tier 1, that's the heavy rail. So tier 1 and tier 2, heavy rail, light rail, they're treated differently. You can see some examples here, BART and Caltrain for heavy, Metro LA, and some of the others down below. Now, what can be built in general, there are some overall caps or requirements for what can be built under, excuse me, SP 79. At a bare minimum, they have to have 5 dwelling units. They also have to hit a density of at least 30 DU per acre. Or if your city or county has a higher min, then they have to hit the higher min. And then there's a cap on the size of the SP 79 units at 1750 square feet. Right. So that does take some of the fun out of it for luxury apartment developers that might see dollar signs around major transit stops. But 1750 is still pretty big. You can charge a penny for that. So let's get more granular on the tier 1 heavy rail. What are some of the development standards? We talked about minimum density. We talked about maximum size. Now, this is where the variation really comes in. It's on height, density, and FAR. And you can see how it tiers, right? Going from the outside of the wedding cake to the in, or if you want to use a target analogy, going toward the bullseye. Within that half mile, but not within a quarter mile, you're looking at 65 feet, 100 DU per acre, an FAR of 3. Plus, if they qualify for a density bonus, they do qualify for a density bonus if they hit at least 75 DU per acre. Then when you go to the next ring inside, that quarter mile ring, that height jumps up to 75, the density up to 120, FAR to 3.5, and they also qualify for a density bonus if they hit at least 90 DU per acre. And then if you're immediately adjacent, and that's defined as within a 200-foot radius or distance of the major transit stop parcel, then you go up to 95, 160, FAR of 4.5. And then notice the double asterisk at the end of that half mile line. And that's because cities with, this is that Beverly Hills carve out that I was talking about, cities with a population of that's smaller than 35,000 are exempt from that half mile. That half mile radius doesn't exist for them. For them, these kick in at a quarter mile radius. Tier 2, it's very similar. It's just all the numbers are knocked down a little bit because I think the legislative intent here is that around heavy rail, the development can be more intense, and around light rail, it can be lighter, but it's still pretty intense if you look at it. 80, 100, 140 DU per acre, really high FARs, and density bonuses kick in at even lower densities, 60 and 75. Again, small cities are exempt from that half mile portion. Now, what are the legal effects of a project qualifying for under SP 79? Well, they are projects under the HAA, and I don't know why the legislature had to go out of its way to say that, because I think by definition they would be anyway. But that invokes a whole set of considerations, right? Under Subdivision J of the Housing Accountability Act, you have to tell them within a certain number of days, depending on the number of units, if any aspect of their project is inconsistent with applicable objective standards. And if you blow that deadline, their project is deemed consistent, regardless of how tall it is, how contrary it is to your objective standards. If you don't tell them within that deadline, it's deemed consistent. And the result of that is that the agency cannot deny the project or reduce the project with conditions based on well, it just can't without making some specific adverse impact findings, which are really, really hard to make. Okay, so that's the first note, is that an SB 79 project is also handled under the HAA. Any of your local standards that conflict with SB 79, like your height, your FAR, your density, they're all preempted. But your local standards that don't conflict with SB 79 are still in play. They are eligible for early vesting with a preliminary application under 65941.1. So keep that in mind, that they might vest a good long while before the application comes in. So if you have changes in your standards, if your standards are in flux, they might not be subject to those new standards depending on when they vest. And then lastly, if they have an affordable component, there's a decent chance that the projects also qualify for streamline approval under SB 35. So think about the layers, right? Just because it's an SB 79 project doesn't mean that you don't have to think about other laws like the Housing Crisis Act, the Housing Accountability Act, SB 35. So it's great. It's great. We get to think about a lot of things as planners and lawyers, right? There are some limitations here, and a project that qualifies under SB 79 is still subject to local inclusionary housing ordinances if you have them. So they do have to provide affordable units or pay fees in lieu. And if their project, the SB 79 project, requires the demolition of any housing that's there today, then relocation assistance and replacement requirements kick in. And then lastly, if the project is over 85 feet in height, then the project applicant has to use union labor. And presumably, I mean, ostensibly that's tied to the different product type that you need. Over 85 feet, I think it'd be hard to do just wood frame lumber construction. And so you need welders and other union labor. But obviously it's just a concession to labor unions. You do have some options as local jurisdictions to kind of come up with a bespoke, I won't say replacement, though I guess it is. It's a replacement, even if it's temporary. You can have your own TOD ordinance, and it has to have HCD approval, whether it's temporary or permanent. A temporary one's only good, I think, until the 7th cycle or a year after the 7th cycle. We'll get to that in a second, I think. But what's the benefit of doing your own even temporary TOD ordinance? Well, it allows you to exclude some sites that would otherwise be eligible for SB 79 but you get, for example, based on fire hazards or historic nature. But at the end of the day, you're going to have to move that excluded potential to somewhere else, and we'll get to that in a second. Alternatively, you can adopt a permanent TOT, or I'm sorry, I think that's supposed to be TOD, alternative plan. Again, it needs HCD approval, and it has to hit or exceed what people could get under SB 79. Just a note on this. So why do it? It's because it allows you to position it a little more, to kind of customize where it happens in your jurisdiction instead of just wherever SB 79 says. I don't have a slide with those details, I guess, but it does allow you to kind of protect that little historic district, move it out of the fire hazard area, but you kind of have to pump it up so that the net result is the same as what it would be under SB 79. Now, I don't know how many of your jurisdictions have a transit agency that owns property around those major transit stops, but I assume that at least some of you do. And you need to know that the transit agencies themselves can create their own standards, and they can go up to as much as 200% of those SB 79 limits. that's gigantic, right? When you think about it. Some of those densities were in the hundreds under just SB 79. So a transit agency could pump that up to the double hundreds. It's quite a lot. Uh, they can prohibit lodging uses, and there is a local veto right for overheight projects, and we can provide more details for the curious about that. Now I'm going to pause for a second because I understand that either Chelsea or Dov from SACOG has some information to share on this.
Yeah, thanks, Todd, and hi, everybody. Good to see everyone. So I just wanted to just really quickly talk through some of the eligibility stuff that's specific to our region. So we are, as the MPO in statute, responsible for creating a map of the TOD stops and sort of the affected zones within the region by tier. And per statute, that map has what's called rebuttable presumption of validity for use by applicants and local governments. So it is sort of important that we get that map right. We're working on creating it now. Again, just wanted to briefly talk about kind of eligibility so everyone has a sense of what this means in our region. First of all, as Todd mentioned, we are just talking Sac County here, and actually only in that tier 2 category, because we don't have heavy rail and some of those super high frequency passenger rail. So it's really light rail stops and then bus rapid transit, and then that is defined in this part of statute. It has a few different conditions, but think about it as in terms of, it needs to have dedicated lanes and 15-minute frequencies. And we actually don't have any existing bus rapid transit. We'll get into planned in a second. So it's really, light rail is what the main kind of impact is here. So again, existing transit is what qualifies. And then I think one thing I should note is that the statute has this really interesting definition of the stations themselves. So it's not the same as how it was in 2097, which Todd mentioned before, which is basically just like where is the the GTFS stop in Google Maps for the station. In this statute, it actually requires that we draw the buffer around any and all pedestrian access points to the station, which is not specifically defined in statute. So there's a little bit of interpretation happening here. But so when the map comes out, you're going to see for each station, each of these light rail stations, there's going to be anywhere from 2 to 5 different dots around each of these existing stations where pedestrians can access the station. The bill also allows for some planned transit to qualify as a TOD stop under SB 79. It's only planned transits that, there's 2 different conditions. One, that it's included in SACOG's Transportation Improvement Program, what we call our MTIP, or it's a route for which the statute says preferred alternative has been selected. So in our region, we have both of those things. On the tip side, that brings into play a few infill light rail stations that we have in our tip that are planned. So we have the Horn Station, Dos Rios Station, and Rail Yard Station that are all kind of in the tip. So those will get turned on. And then there's a couple new stops on the streetcar that is acting as a light rail in downtown Sacramento. And then on the selected alternative provision, that brings into play the Green Line extension from downtown Sacramento through Natomas. So all in all, when we release the map, I know we have a regional audience here, but this bill is really, from the onset only affecting the city of Sacramento, Rancho Cordova, Folsom, and then Sacramento County. But as Todd mentioned, for unincorporated areas, that doesn't kick in until the next RENA cycle, which for us is in 2029. So in terms of next steps on the map, we're creating that now. We're kind of actually vetting some of those points with Sacramento RT, just to kind of make sure that we're thinking about this the same way they are. We've started doing some individual calls with some of our affected local governments. So I think you've probably all heard from me by now from the jurisdictions that I just mentioned. And we'll sort of have a chance to kind of vet some of our interpretation there. But you can expect us to release the map in the early part of the new year. I think we're trying to, we want to get it right, but we also want to give you ample time, right? So, July 1st is when this kicks in. So there's, we want to be able to provide you a map as soon as possible so that you kind of have time to prepare. If anyone is choosing to go that sort of local TOD alternative plan route, you have, the information that you need to start going on that, recognizing that there's going to be a timing challenge with the guidelines by which HCD is sort of going to be evaluating these and approving these TOD alternative plans. Those guidelines, as an FYI, might not come out until close to they're from a statutory perspective not required to put that out until I think July 1st. I would not expect them super early. I would expect them close to that date. So you are kind of operating in the dark a little bit, but we just want to make sure that you have the map as soon as possible so you can start doing your planning. That is all that I have. I think we're doing questions at the end, but happy to answer questions from a SACOG perspective after. Back to you, Tom.
All right, well, thank you, Dav. And thanks for your patience as we switch back and forth the screens. I didn't want to leave you all stuck on pause. Yeah, it's so great that we have access to SACOG experts to help in the implementation of these kind of things. And we see this with a lot of state laws, right? HCD, the law imposes requirements, and HCD is figuring out the guidelines and the like. And sometimes the guidelines come after the obligations are due. So, but it's not the end of the world if you consult with your teams, with SACOG, maybe with your city attorney, your county council, and you come up with an alternative plan that you think should fly, and then SACOG's guidelines come out and suggest that maybe a change might be needed. So you pivot, or you don't have it approved just yet, but you've got most of the work done. It seems like a smart idea if you're interested in doing one of those local alternative plans to get started sooner instead of waiting for the guidelines. Let's see here. Get this going again. Now we're on to the second preeminent bill that everybody seems to be thinking about, and that is bills, I should say, AB 130 and SB 131. Those are both budget writer bills that were signed on June 30th. They took effect immediately, most of those parts. And so we're already living with these bills as opposed to SB 79. Now, what are the main things that these bills did is they amended the Permit Streamlining Act and CEQA, and those two kind of tie together, and we'll get into that. The apparent goal here is to accelerate housing approvals and, by, among other things, expanding CEQA exemptions and strengthening accountability timelines, which I think really means shortening. So this is the big picture of what these two bills have done. The Permit Streamlining Act now applies to, among other things, ministerial housing approvals. That was never the case before. But now ministerial approvals are subject to the PSA for housing, not all ministerial approvals. There is a new CEQA exemption for certain infill housing projects, and that drives even shorter approval deadlines for discretionary projects that qualify for that new CEQA exemption. There are also relatively short deadlines for those ministerial housing approvals. And if you miss the deadlines, it's automatic approval. To be clear, these are deadlines for approving or denying a project, not for planning and clearance, not for intermediate steps. It's for approving or denying the project, getting all the way to the end. Okay, so on the ministerial project side of these changes to the PSA, the agency has to act, you can see, within 60 days of getting a complete application. Please note that that is not 60 days from when the city or the county sends the completeness letter. We've reviewed your application and confirmed that it's complete. It's 60 days from when they give you a complete application. And a failure to act is deemed approved automatically. So that should make all of us kind of perk up a little bit, because when projects get deemed approved because we delayed, people turn a real critical eye on us and our performance in our jobs, right? There's also this accelerated timeline for discretionary projects. In general, the deadlines for making a decision under the PSA historically have all been driven off of the CEQA determination, right? You have to approve or deny within X days of a CEQA determination. Well, the PSA previously only ever applied to discretionary projects, so CEQA was always in play. And so the CEQA process itself is what drove the decision deadline. And that was rarely an issue because, as a practical matter, almost every agency would make their CEQA determination at the same meeting where they were making a decision on the project, right? So there wasn't a gap in time. Those CEQA decision plus X or Y days were never really in play. Well, now if a discretionary housing project qualifies for that new infill CEQA exemption, there's just a hard calendar stop for making a decision. And it's really short. It's within 30 days of the later of the completion of a tribal consultation, which is embedded in that CEQA exemption, or the deadline for making that Housing Accountability Act consistency determination. That's what I was referring to earlier under Government Code 6585. What is it? 65859.5, I think it is. Subdivision J. Subdivision J of the Housing Accountability Act gives you your deadlines for making consistency determinations. And this builds on that, or borrows that timeline, by saying you have to actually approve or deny that discretionary housing project within 30 days of the later of the end of your tribal consultation or that consistency determination. So these are more dates that you're going to want to circle on your calendar with a red Sharpie when you get a project. And the tip off would be, if it's a project that seeks to qualify for that new infill exemption, then you know that you need to start looking at the timeline for tribal consultation, for consistency determination, and then count out 30 days and mark that and vigil that deadline. Because again, if you miss the deadline, it's an automatic approval. And unlike before, this is another reason why PSA deadlines were rarely an issue, is because before, people couldn't even press an applicant couldn't even get an automatic approval without giving notice and an opportunity to the agency to cure the delay, which basically just means, hey, I'm going to push for automatic approval, and then the agency schedules the hearing and they can approve or deny as based on the findings. But now there's no more opportunity to delay. So if you blow the deadline, you're not going to get a notice. You're not going to get an opportunity to cure. It will just be automatically approved. And to many cities and counties, that feels like a nuclear option, right? So keep that in mind. It becomes very political very fast, like I said, when projects get approved just because we waited too long. As for the CEQA, the new exemption, I won't get into the hairy details of how to qualify for it. It's kind of complex, but just know that it's tied to that 30-day deadline. The post-tribal, post-HAA consistency deadline. Now SB 131 was really focused on the CEQA aspect, that new exemption. AB 130 was focused on the PSA and how it kind of borrows the CEQA exemption from SB 131. But there's another aspect of this, of CEQA, that SB 131 creates, I guess, and it's this near miss, which for those of us that do SQL work, this is kind of novel, right? That you can almost qualify for an exemption. And usually, we're all used to working in a world where you either do or you don't qualify for the exemption. It's very black and white, but now there's SB 131 introduces this concept of a near miss, where if you miss the exemption due to just a single condition, then you get to have this kind of pared back SQL evaluation, where the evaluation really focuses on just that thing that you missed. So this will be something for planners and SQL practitioners in general to vigil and kind of understand as we go. Another thing that SB 131 did for CEQA is that it added new statutory exemptions for housing element rezoning. That should come as a welcome change to many of us, because the housing element rezoning in the past would sometimes get gummed up when it was extensive, and some people thought that it needed a full EIR, or even a mitigated neg deck might have taken a little while, and that really delayed CEQA, or the housing element certification, was doing the CEQA for the rezoning when a jurisdiction was late and certification depended on the rezoning. There's also a new exemption for ag employee housing, and there's some others for housing related activities that I won't go into. It does affect how we as CEQA practitioners handle VMT. As we know, VMT is the new measure of traffic impacts, has been for a little while. Now, instead of directly mitigating their project, a developer can just pay into an HCD administered VMT mitigation fund. Or they can still do affordable, they can do offsite housing or improve infrastructure. But there is this new option now for just paying into the statewide fund and calling it all good. I don't know how that trickles down to the local jurisdictions so that you don't actually see VMT impacts or traffic impacts in your neighborhood because of that project, but this is now available to developers. Another thing that these new bills did is that they imposed some building code restrictions, namely your local jurisdiction. And I don't know how many of you on the planning side are really hands-on on this, but I know you collaborate a lot with your building officials, and they know, or they need to know, that there will be no new local building code modifications for residential for a good while. There are limited exceptions for health and safety, unique local circumstances, but it's not just, as opposed to before, when the local agencies' determinations of what's necessary for safety, what's the unique local condition, those were kind of just granted a ton of deference. Now it's all going to be vetted pretty heavily by the state. Another thing these bills did is that they removed several sunset provisions from existing housing laws. We're probably all used to seeing these. Most of the new laws are floated as temporary, but then 2 or 3 or 4 years later, the legislature comes back and removes the sunset provisions, so now they're permanent. This shouldn't shock any of us that work in this space. Even new aggressive temporary bills have a way of becoming permanent over time in California. The net result is that formerly temporary reforms are now permanent. There's also a requirement that cities and counties annually inspect homeless shelters. I emphasize that because I don't know if that falls within your wheelhouse or not. But someone from your agency is going to have to inspect every year those homeless shelters with an eye to ensuring that they're safe and habitable and etc. Okay, I'm going to take a deep breath. We've got this next section is about other bills, and we're just flying at 50,000 feet, kind of, to give you an overview of some of the other housing bills that hit. And we've grouped them by themes. And I hope that this is helpful in kind of seeing the general direction of where state law has gone, where it's going right now, and to kind of sensitize you to when to drill down. Just as a preview, the themes of these new bills are to provide stronger state oversight, of course. So that means pumping up HCD authority, changing how RENA works and is accounted for. Another theme is faster project approvals with streamlining and shot clocks, kind of like we just saw. The legislature continues to tinker every legislative session with ADU rules and with what we still kind of refer to as SB 9, as well as other, there's a growing list of privileged housing. This time we saw some more dealing with adaptive reuse, with campus housing and tribal housing. We'll get into those. And then there's greater accountability, greater penalties. Attorneys' fees are expanded. And then there's a focus on equity, with the state having to translate housing materials with tenant stability measures and some rural support. So these are the themes, and we'll see these as we get into the different groups. The first group here is for our bills that affect housing planning and RENA coordination. I'm going to pause here after the first one because we have these bills that really accelerate the timeframes for COG collaboration and interaction with cities. And I think, Chelsea, that might be you, right?
Yeah, thanks, Todd. So I just wanted to offer a few comments here in response to some of the AB 1275 provisions Todd is speaking to. So AB 1275 essentially accelerated the timeframes for when HCD is required to consult with SACOG and when HCD issues the regional housing needs determination to us. So all of this to say that we are aware and we've been keeping very close tabs on AB 1275 and how it impacts our RENA schedule. We've been in conversation with HCD. The good news is that the bill's accelerated timeframes for the consultation and determination issuance give us more time as the COG and a region to prepare for and create the RENA methodology together. So they didn't really change any of our timelines for when we do that. And many of you have heard me say this, we will be kicking off that work in the summer of next year. So you can expect to see more updates from SACOG at the beginning of next year, but there's no sense of urgency around this now. We are tracking it and we'll be issuing updates to this group when the time comes. Okay, back to you, Todd.
Thanks, Chelsea. Yeah, I'll tell you, we're already getting questions on this and related questions from clients because we're all still smarting from the 6th cycle. Maybe somebody on this call is still working on getting certified. Or certainly we're all working on implementing 6th cycle housing element programs. But we're getting questions from clients about the 7th cycle. And we can talk more about this in the Q&A portion, but the consequences have really grown for being late. We saw that a lot in the 6th cycle. It's going to be pretty heavy in the 7th if we're late. And so cities are talking to us about what can we do now? Before we get our RENA allocation, what can we do now? What should we be thinking about? And we can talk about that. In fact, yesterday I did another webinar on how to prepare for the 7th cycle. But back to the bills here. We've got some improved coordination between councils of government, HCD, and metropolitan planning organizations for RENA. We've got a simplified path to get a pro-housing designation for rural areas. This applies to cities with populations smaller than 25,000 or that are in a county with a population that's smaller than 600,000. We've got some stability, I should say that when you're going for pro-housing designation, you can now count tenant stability measures that your agency has adopted toward points to get that designation. And there's another bill that clarifies housing element law, so that when there's a conflict between different general plan elements, the most recent element controls, the most recently adopted element controls. And that's a real issue, right? Because a lot of times the housing element leads and the land use and maybe other elements are updated in the wake of the housing element update. So that's helpful. As housing element practitioners, that can be helpful. And then, for a while, HCD has asserted that it can and will, and sometimes does, decertify a housing element, an agency's housing element, if they are not implementing their housing element programs. And this now is expressly addressed here, where they can decertify if an agency is late in removing constraints. And I think late will boil down to whatever deadline was in the housing element program, whatever the promise was that was made. Oh yeah, and now there's this obligation in the housing elements going forward to disclose if the agency has adopted a new or more restrictive government constraint. And keep in mind that a constraint is often in the eye of the beholder, because as I like to tell clients, what has no constraints on housing? No zoning. That has no constraints. And if you're going to have zoning at all, inherently there are going to be some constraints. So this idea of constraints is sometimes squishy. It is subjective in the sense that HCD might see something as a constraint that you just see as a reasonable, orderly regulation of development. And that's often the conversation that we have with our friends at HCD is, let's tease this out a little bit. Why do you think it's a constraint? Do you have any evidence to back that up? We don't have any evidence that this regulation has been a constraint. We have numerous projects that have been able to follow this regulation and still happen. So that's a bigger conversation, I think. Maybe it's just fresh on my mind coming from my housing element webinar yesterday, but it's something to think about as you consider these new bills. Now, the next group is about accountability, enforcement, changes to legal remedies. We have attorney's fees going to prevailing housing applicants with increased fines. We have HCD having to translate housing materials for public accessibility. I think that speaks to accountability more than enforcement. LAFCOs themselves have to have written public procedures for their processes. I think that was probably a general practice before, but now it's a statutory requirement. And then we've got the extension of post-entitlement phase permit streamlining that I hope we're all getting familiar with. Now that applies to state agencies too. And that can be important, like with mobile home parks, where the state, not the local, is usually the one issuing even post-entitlement phase permits for mobile home parks. But yeah, now the state's kind of in the same position as us cities and counties. Speaking of streamlining and permitting reforms, we have timelines for plan check. And then there's this, which when I stop and think about it, this is a little crazy. That if your timeline, or if you're taking longer than 30 days to do the plan check, the applicant can go and get their own private plan checker. Think about that for a minute. Somebody who's getting paid by the applicant is going to be doing the plan check. They might not see the world the same way as the agency planners do. So it remains to be seen how conflicts between agency planners and these private plan checkers are going to be resolved. So this is just an area to keep an eye on. Of course, we can avoid that by just turning them around real fast and eliminating their need and their right to get a private plan checker. We also have a 10-day inspection shot clock for smaller projects. That's building inspections, construction inspections. I realize that might not be you as planners, but you do interact with them a lot, and you should let them know, if they don't already, that new laws do create some shot clocks, some very short shot clocks for their inspections. We have a bill about enabling adaptive reuse, making those approvals ministerial, creating some incentives. And then we have some an extension of streamline approval to campus development zones. And I understand that some of you are with agencies that do have an interest in or partnering with educational establishments for campus related housing. ADUs, junior ADUs, and other small scale housing, we saw, as we do every legislative session, we saw some changes to ADU law. We saw clarifications for small ADUs, and that includes juniors. They don't have to pay school fees. We saw some clarifications on how square footage is measured. Interior livable area, I think, is the term now. And just procedurally, we've long had to submit ADU ordinances to HCD for their review, for HCD's review within 60 days of adoption. Well, now, if we blow that 60-day deadline, the adopted ordinance is invalid, automatically invalid. So don't miss the deadline. None of us were missing the deadline before, and we certainly won't now, right? So, and it also becomes invalid if we timely submit it and HCD sends us back comments saying, hey, you actually need to fix a couple things, and the city or county doesn't reply within 30 days. If you blow that 30-day response deadline, it also becomes automatically invalid. Now that automatic invalidation of extends to the entire ordinance, not just to your update. It makes your entire ADU ordinance null and void. And for a lot of jurisdictions, that is unacceptable. To be even a moment without a valid local ordinance on ADUs. Because what happens is an ADU application that comes in during that time when it's void, it has to be processed and approved under just the 2 or 3 standards that are in state law. That means no regulation of how it looks, no regulation of height, no regulation of a setback, except for the 4-foot side and rear. And for a lot of cities, that is just unacceptable. So, as we do every year, be sure to update your ADU ordinances before January 1st. It's getting late. It always is late. A lot of cities will do emergency ordinances or urgency ordinances, and they will closely chase them with a normal ordinance, adopting the same update to minimize the amount of time that you're hanging out there with just an urgency ordinance. But the urgency ordinance allows you to get it done by January 1st. A different SB 9, not the one from 2021. It's sometimes confusing because we do reuse bill numbers. We have to. Or I should say, this is the old SB 9. AB 1061 extended the old SB 9 to, or not extended, but it refines where SB 9 can happen relative to historic districts and historic landmarks. If SB 9 projects are a thing in your city, you'll want to pay attention to this bill. I should mention that a new SB 9 was part of, as you can see in number 3, was part of the ADU changes as well. Moving on, we have some specialized housing development. I mentioned adaptive reuse earlier. We've got expanded opportunities for ministerial approval with campus housing. This is kind of nice, actually. The tribal housing agreements, it's now very clear that they can count toward RHNA. So for those of you that work for an agency that is close to tribal land, and it's not just housing on tribal land, I should say, it's housing anywhere that's tribal housing, whether it's on tribal owned land or in the middle of your downtown. So that's nice. And then we've got some exemptions for community college housing to be aware of. We've got data reporting, financing tools. There's some changes to the APR process for tracking demolished or converted units. This is significant, that's why we put it in red. You can now get credit toward conversions of housing to affordable units. So that's really nice. That might be one of the lowest hanging fruits. And then we've got some changes to how EIFD and other laws, which I personally hope you don't have to deal with that, but you might. To me, that stuff just I glaze over. But now here's a summary of our theme. You can kind of see that the attention was spread fairly evenly over most of these themes. We had 6, 4, 5, 4, 4, and 2 bills. So that's 22 total. And that's a lot. It's a lot to digest. Now, I'll take another breath. We're going to talk about 2 cases that have come up frequently in my practice, and I think they might come up in your roles in your cities and counties. The first is the one that everybody seems to be talking about right now, the new commune versus Redondo Beach case. It was just decided. And this deals with the use of overlay zones to satisfy RHNA. I bet if I asked you all to raise your hand if your jurisdiction uses overlays for your RHNA, I bet a bunch of you would have your hands raised because it's so common. Now, in early October, the 2nd district down here near LA ruled, well, they were asked to decide whether Redondo Beach's housing element, which relied on overlay, complied with the housing element law. Now, just for background, what happened was they adopted their housing element for the 6th cycle. They included a bunch of non-vacant sites that some were commercially zoned to meet their lower income. And they used an overlay strategy like many of us did, adding residential allowances on top of that existing commercial and industrial base zone. So we all understand the setup, right? There's a non-residential base zone. To hit their RHNA, they impose a new residential base overlay on top of that base zone. And the court didn't like it because they were trying to use that overlay to satisfy a housing element law requirement that rezoned sites have to hit a minimum density. And in this city, it was a minimum density of 20 DU per acre. And it might be common sense when you stop and think about it, but when you use an overlay that still allows non-residential development, how does that satisfy the minimum density required by the housing element law? Well, it doesn't, and the court recognized that. that an overlay that creates residential capacity, if it still allows non-residential, by definition, it cannot satisfy the minimum density that's required under the housing element law. And the key here, you can see it in red, was that the residential use was optional under the overlay. A property owner didn't have to use the overlay at all. They could just use the base zone. The court also got into some other aspects of the project, which was this wasn't a residential only use. Well, I'm not sure how much time I want to spend on this because the real key was what I just mentioned. So, yeah, the real key is what's in red, that it still allowed non-residential zoning. It still allowed projects with no house. So there was also this aspect too, that one of the sites, at least one of the sites they identified in their inventory, it had a grocery store in it as a lessee. The lease was long-term. The lease allowed that tenant to basically keep going as a grocery store indefinitely. And so the court was taking a really hard look at the realistic potential. That is a requirement for your inventory sites, is that the city or the county has to pick sites that have a realistic potential to turn into housing in that planning cycle. And so the court was persuaded that the fact that this lease had a thriving grocery store there that wasn't going in, there was no evidence suggesting that the grocery store was going anywhere soon, anytime soon. It wasn't realistic that it would turn into housing. And so what's the point of that? Well, the takeaways, I think, from this are, if you're applying an overlay to satisfy a requirement that includes a minimum density requirement, like you can see under number 1 here, you have to make sure that your overlay preempts the base zone. And at that point, you might as well just change the base zone, right? Because there is no right left under the base zone to do anything other than that's a lower density for residential than what the overlay says. What's the takeaway here? I think it's, for any site that you've got that's non-vacant, you need to pack your record with evidence demonstrating why there is realistic potential for that non-vacant site to turn into housing in this cycle. And the law doesn't say what that looks like, but if there's a long-term lease with a grocery store, and it doesn't look like the grocery store is going anywhere, then if you want to include it in your site, you're going to need to you're going to have to gather and include evidence in the record demonstrating why, actually, with the residual land value being what it is, that lease could get bought out in a heartbeat by an apartment developer because they're paying more than that for land today, or something like that. You might get comps from a realtor, from a broker. We can be creative, but we need to be creative in gathering and providing evidence in the record. Another side note here, because this has come up a lot, is that while we all kind of breathe a sigh of relief when HCD certifies the housing element, we're not exactly out of the woods yet, both in this case and in the Clovis case that's kind of similar. HCD had certified the housing element, and somebody else was challenging it. And the courts again reiterated that the courts, not HCD, are the final arbiters of whether a housing element complies with housing element law. So it's just something to keep in mind. I mean, of course, we're all paying very close attention to HCD's input. HCD is given a significant amount of deference, but not so much that they can ignore a minimum density. These are the significant implications. I think it's kind of a summary of what I already said. An overlay zone that permits zero housing or less than the minimum can't satisfy the minimum density and housing element law. Rezoned sites must require residential use at that minimum density. Non-vacant sites must have evidence, credible evidence that they can be that they are likely to be redeveloped. And just a note at the bottom that if your city or county is relying on what I'm calling a transparent overlay, one that still leaves the base zone intact at either a lower or non-existent residential capacity, in light of this case and the Clovis case, you should be nervous. You should be nervous if you're using an overlay to satisfy a minimum density requirement, because it makes you, under these holdings, it makes your housing element non-compliant, and that leaves your city or county exposed again to builder's remedy. And as soon as somebody figures that out, as soon as an applicant figures that out, and they want to do something that they can only do under builder's remedy, they will probably look at your overlays and see if they're suspicious under these two cases. And when I say the two cases, I really mean the New Commune versus Redondo and the Clovis case, which was basically the same thing with just low density residential instead of non-residential. Okay. Second and last case, Ohio House. I don't know if you've heard about this one before. It is a little bit older. It was decided right at the end of last year, but the ripples of this case have really traveled widely this year, as many of you might know that Costa Mesa, California, down in Orange County, has a group home ordinance, and they specifically call out group homes for certain requirements, both sober living homes and other kinds of group homes. The ordinance requires a CUP for group homes with greater than 6 residents. And it requires a 650-foot separation between group homes, all in the name of spreading it out so that residents of these homes get to live in something that approximates a normal residential experience. I think the policy concern there was if the state wants to make these available for folks that need a group home experience, then it's all with an eye to integrating them more fully into the larger social fabric, so that they can enjoy housing on an equal basis with everybody else. And they have to be spread out by at least 650 feet, according to Costa Mesa, 650 feet. They have to be spread out so that it doesn't result in sort of a group home cul-de-sac or an overconcentration where they then lose the benefit of living in a quote normal neighborhood, right? So that's what was driving the ordinance. And the petitioners here were sober living home operators who said that especially the separation requirement was discriminatory under the Federal Fair Housing Act amendments and California's equivalent. They claimed disparate treatment. You're not treating us the same, you're discriminating. There's a disparate impact. And we asked for an exception to all this as a reasonable accommodation, and you didn't give it to us. Well, the Ninth Circuit, which is not a very conservative circuit at all, right? The Ninth Circuit actually upheld the ordinance, affirming judgment for the city, holding that there's no disparate treatment here because the ordinance didn't discriminate against these group home operators. Instead, it actually gave them a special benefit. They could boldly go where non-disabled boarding houses, that was the closest analog, non-disabled boarding houses could not go. And yet group homes could go there. They got this special benefit. They weren't being discriminated against, they were being discriminated in their favor. And as a result, and the court held that when you're granting a special benefit like this, you can't attach strings to that benefit. So, and that was the basis that it used for saying, well, you have to get a CUP if you want the special benefit. And you have to abide by the separation requirements. The court also ruled out or rejected the claim that there was a disparate impact, that because there was just a lack of evidence that there was a significant adverse disproportionate effect on the disabled in this case. And their requested accommodation to ignore the spacing rules were not reasonable, right? Remember, there are limits on accommodations. They only have to be reasonable. We only have to grant accommodations that are reasonable. And it's not reasonable to ignore that spacing requirement, the Ninth Circuit said, because that would fundamentally alter the city's zoning program. If it allowed the concentration of group homes and it would blow up the whole reason for an R1 neighborhood or for that matter, a residential neighborhood altogether if it starts to feel really institutional. And as a practical matter, the group homes tend to operate like short-term lodging because they have a lot of turnover. So the key takeaways from the Ohio House decision, this decision reinforces cities' authority to regulate group homes as long as the rules are neutral, evidence-based, and allow reasonable accommodation when it's justified. And as we saw, it's not always justified. The reason why I'm bringing this up is because in the 6th housing element cycle, HCD insisted that affirmatively furthering fair housing requires all cities to allow group homes of 6 or more in all residential zones willy-nilly, with no CUP, with no discretionary approval. So while HCD is not looking at Fair Housing Act amendments, they're not looking at the California equivalent, they're not looking at the same laws that the Ninth Circuit was considering. So there is this the Ninth Circuit decision here kind of opens the way for local cities and counties to regulate group homes under the federal and state Fair Housing Act and disability laws. HCD, meanwhile, is still asserting affirmatively furthering fair housing requirements for group homes. And there is a way to dovetail those and make them work together. We've done this for a few clients, but you'll know it. I mean, maybe in your fair city or county, group homes aren't a thing yet, but you will know it immediately when they become a thing because it's like a political firestorm. And the need to regulate will become very obvious very fast if you haven't already done that. So it's something to take away. I know it hit late 2024, but like I said, we've been unpacking it this year, so I thought I'd include it. Now we've got some practical considerations. This is the last section, and then we'll move over to Q&A. Just in general, increasingly common are these hard deadlines, especially for housing projects, right? Mostly for housing projects. Hard deadlines to approve or deny. Now, I don't expect you to read everything on this slide. I'm only throwing it up here so that you can kind of see the volume of laws that are on the books today that impose a hard deadline for approving or denying a project. And that's, like I said earlier, that's not just the planning department. That's all the departments in the city or the county. You have to get all the way to a final decision within these timeframes. And so it's becoming increasingly common. There are consequences to blowing those deadlines. Almost always the application is deemed approved. And it's very important that each of you understand this. And every department in your city has to understand that deadline clock, that shot clock for making a decision does not stop when you give them corrections. It does not pause. Nothing pauses it except for a decision, or in some limited cases, the applicant can request a pause, but not all laws allow even that. And so you have to take care how you respond with comments and corrections. And this is this is where I'll stop now before the Q&A. We can get into this if you like, about how to respond with corrections when you've got a hard deadline for making a decision. And with that, I'll turn it back to Chelsea.
Thanks, Todd, for that comprehensive overview. We really appreciate it. So now we're going to go ahead and stop the recording.